Hi there, my name is Krista Ulrich, and I have done a literary analysis of competency to stand trial. So, a person who has been charged of a crime will likely at some point in the legal process go to court to either be acquitted or convicted of those charges. All Americans do have the right to competency when they are standing trial, and so the definitions and requirements for competency have been things that have been evolving and progressing over time. So, starting with that progression, we're going to first focus on a little bit of the history. The history is going to take a look at a series of Supreme Court cases that helped lay some of the groundwork for what competency is today. So the first one we're going to look at is the Dusky v. United States case in 1960. So Dusky was a man suffering from schizophrenia, and he was charged with kidnapping and rape. He was convicted of his charges, but he felt he was not competent to stand trial. This case was then taken to the Supreme Court for review, and after the courts reviewed it, they did decide that a defendant must have a sufficient ability to rationally consult with his lawyer and a rational and factual understanding of the proceedings. So, in short, what this means is that basically a defendant must be able to understand the charges that are brought against him or her. They have to be able to understand the consequences that go beyond just serving jail time and the consequences of being found guilty or not guilty. And then they also have to be able to aid their attorney in their defense. They don't have to know all the ins and outs of the law, but they do have to be able to go up on the stand and not basically hurt their case. This Supreme Court case also did determine that a brief mental status exam was not enough to find someone competent. It had to be a complete evaluation conducted by a licensed professional. So the second case we're going to take a look at is the Pate v. Robinson case in 1966. So in this instance, Robinson was charged with murdering his common-law wife at the time, and even though his defense argued that he was insane at the time of the murder, the courts moved way too fast, and they didn't allow for a competency evaluation to be conducted. This case was then brought to the Supreme Court for review, and they determined that because the courts moved too fast and he wasn't allowed to have a competency evaluation conducted, it was in violation of his 14th Amendment rights, and he was not basically, in essence, given the right of due process. So this case set the precedence that an evaluation to determine competency to stand trial was required by law for anybody whose competency was in question. Third, we have the Jackson v. Indiana case in 1972. So in this case, Jackson was a deaf mute who had some intellectual disabilities and was charged with 2 separate robberies. An evaluation showed that Jackson's condition was enough to find him not competent, and so therefore, in an effort to possibly regain this competency, Jackson was committed to the Indiana Department of Mental Health. However, the doctors that performed his competency evaluations and doctors at the mental health facility determined that it was unlikely that Jackson would ever regain his competency. So this in turn meant that Jackson's stay at the Indiana Department of Mental Health would likely be a life sentence, as he would never really regain that competency. This case was brought to the Supreme Court, and they decided that the keeping of Jackson in a mental health facility for an extended period of time was a violation of his 8th Amendment right of cruel and unusual punishment, as well as a violation of his 14th Amendment right. Because of this, this case actually set the precedence that persons found not competent cannot be held in mental facilities indefinitely. They do have to go back to the courts, and the courts have to figure out another course of action to take if someone cannot be found competent. Next, we have the Drope v. Missouri case in 1975. So in this case, Drope was charged with the rape of his wife, but during the trial, it was found that he had severe mental conditions that hindered his ability to competently stand trial, and professionals found him actually not competent to stand trial. However, because it was psychologists bringing it up and his lawyers bringing it up, but not Drope, he was still convicted of his charges and sent to jail. However, this did make it to the Supreme Court, and they reviewed it, and this case then set the precedence that it is not the sole responsibility of the defendant to bring their competency into question. It can be psychologists that perform evaluations, it can be their lawyers, it can be anybody else in the court system. The responsibility does not fall solely on the defendant. Alright, and lastly we have the Cooper v. Oklahoma case in 1996. So in this case, Cooper was going to trial for first-degree murder, and he exhibited behaviors that were not generally acceptable for someone in a mentally stable frame of mind. On more than one occasion, there was an evaluation presented to the court that recommended Cooper was not competent to stand trial. However, the state of Oklahoma had laws in place that required that there be clear and convincing evidence that Cooper was not competent. So, Cooper was actually convicted and given a death sentence. However, this did make it to the Supreme Court, and the Supreme Court decided that the Oklahoma courts had placed too much of a burden on Cooper to prove that he was not competent. So they had therefore tried and convicted someone who would otherwise not be considered competent. So this case did set the precedence that only a preponderance of evidence is required to determine if a person is competent or not. So, with all of this history and progression of how competency has evolved and the requirements for competency to stand trial, as far as what it looks like today, overall, a person who is charged with a crime must be given an opportunity for a competency eval at the slightest hint of evidence that there may be some mental health issues or anything of that sort. It is not the responsibility of the accused to prove with clear and convincing evidence that he or she is not competent, but with a preponderance of evidence. And to be found competent, an individual must be able to understand the charges brought against him or her, understand the consequences of being found guilty or not guilty, and aid his or her attorney in the defense of their case. So with that in mind, what competency to stand trial looks like today and how the rules, laws, and requirements for it have progressed, I wanted to take a look at what South Dakota competency would look like. So according to South Dakota Codified Law 23A-10A, an individual under arrest must be able to understand the charges brought against him or her and understand the consequences of those charges beyond just the courtroom and jail time. So this is basically almost exactly like the Dusky standard that was set forth in the Dusky v. United States case. An individual must also be able to aid their attorney in his or her defense. So again, that's kind of that second part of that Dusky case. So here, South Dakota is following along with the precedences that have been set by the Supreme Courts before them. Alright, so now that we've taken a peek at South Dakota and its competency laws, I want to take a little bit of a dive into juvenile competency and juveniles in the legal system as a whole. Overall, this topic is incredibly complicated, and it's just simply not within the scope of this presentation to cover it all. But I do want to focus on a couple of key points that I think are crucial. So first we have the issue of rights. When you turn 18 in the United States, you are then considered the age of majority, so therefore you are an adult. With becoming an adult, you are also granted your unalienable rights. In those rights, you have the right to an evaluation of competency to stand trial. Because juveniles are not adults, they do not have that right of competency. So this poses kind of an interesting dilemma as far as making sure that juveniles are competent. So, since they don't have that right to begin with, they cannot be held to the same standards of competency for adults either. So, when an adult is found not competent, oftentimes it's due to a mental disorder that inhibits their ability to aid in their defense and understand the situation that's going on in front of them. However, when it comes to juveniles, there can be an inability to aid in their defense or understand their situation based solely on the fact that they have not cognitively developed far enough. Juveniles are immature and they don't have the same reasoning abilities that adults do. There's a reason that they are juveniles and that 18 is when you get your rights. So overall, this already kind of changes the understanding and requirement of what competency to stand trial actually is. So to kind of circumvent this lack of development as far as it goes with competency, there is actually a court that has introduced a tender years in competency as a facet of competency for juveniles. So basically this means that tender years in competency is essentially referring to juveniles that are too young and immature to understand the situation. Definitely not all courts have adopted this, so it's still something that is not widely used, widely accepted, and there's still a lot of debate about juvenile competency. So that's a little bit on kind of juvenile competency. It's definitely it's a lot, and it's very complicated. However, South Dakota has actually adopted some juvenile competency laws. So first, we have our first codified law. Question of competency can be raised by the juvenile, the state, or sua sponte by the court. If it is possible that a juvenile may be suffering from a mental disorder or illness, an evaluation must be conducted. So this is starting to sound a little bit similar to how it is for adults, which can be a very good thing. So, once it has been determined that there is possibly a mental illness and an evaluation has been conducted, a hearing must then be held for the courts to determine whether the juvenile is to be found competent or not. So, if a juvenile is found not competent, there are two options that can kind of pave the way. So, competency can either be achieved or competency cannot be achieved. If competency can be achieved, according to the South Dakota codified law, the juvenile can be referred to a mental facility and then treated. If competency cannot be reached in reasonable time, charges are dismissed and further action is then decided by the courts. They decide what they're going to end up doing. So, as a whole, competency to stand trial. The definitions and requirements have evolved and progressed a lot over time, from being very bare minimum to having all the laws and regulations in place as to how you're competent, how to get an evaluation, etc., etc. It has definitely evolved with time. So there are now clear-cut requirements of the states for their laws on competency, and while juvenile competency is a substantial topic still debated by lawmakers and scholars, it is definitely something that's very important and will have to be focused on in the near future. South Dakota does have clear laws for both adults and juveniles, however, when it comes to competency to stand trial. So these here are a couple of my references used in the PowerPoint. And that concludes this presentation. I just want to thank you all very much for watching and listening, and have a wonderful rest of your day.